Mr. Madoff waits for his day in court. Victims of his alleged Ponzi scheme wait to find out if they will ever see any of their own money again. What are the chances? Attorney Rick Stone has been weighing those chances. He represents some of the alleged victims, and he joins us once again. Rick, great to see you.
Good to see you.
Where I understand that the authorities have put together about $1 billion or discovered about $1 billion of assets that was involved in the Madoff empire. Is all of that going to go to the victims?
All of that, less expenses that are charged against it, should go to the victims pro rata, yes.
Now, you say expenses. What percent would be expenses?
Well, it's difficult to say. I mean, there are expenses of the trustee and his law firm and things like that that are normally charged against what they recover, but it's going to be a small percentage, very small.
All right. Now, the feeder funds. Obviously, a lot of people, maybe with regret, maybe even with complicity, channeled money directly into Madoff's accounts without doing the due diligence that people like Markopoulos and others did. Can you claw back from them?
If they receive back more than the principal they put in, this trustee has made clear that he's going to seek clawback. So there will be clawback cases. How many, against which defendants, whether it's only domestic and not foreign, we'll wait to see. But there clearly will be litigation on receiving back, through the fraudulent conveyance laws, monies that were received above principal invested.
And there is legal precedence for this?
Absolutely. I had it in a case of mine, the Lipper case. It was done in the Bayou case, and it will be done here.
Now, New York law, I understand, it's much more difficult to do clawbacks, right? Because there's something called the Martin Act. I'm not sure exactly what it is, but doesn't that prevent clawbacks?
No, the Martin Act has nothing to do with clawbacks.
Okay.
Clawbacks is an issue of fraudulent conveyance under New York law. What the Martin Act is, makes it more difficult to bring a case for breach of fiduciary duty against these fund of funds. What the Martin Act says is, if you have a claim for breach of fiduciary duty, which is really a claim that you were there were the misrepresentations in connection with your purchase of securities, there is no such claim. That belongs to the Attorney General in New York only.
Hey, Rick,
so
final question. I just got to ask you quickly. If geniuses like Henry Kaufman, one of the smartest stock analysts, can make a mistake and not be able to see through Madoff, won't all of these feeder funds say, hey, look, if Kaufman couldn't see through them, how was I supposed to see through them?
It's going to be a tough issue for the plaintiffs, not a slam dunk by any means. They're going to come in with file after file of due diligence that they did and still missed it and say everybody missed it. Henry Kaufman, Erwin Kellner, other big investors, other funds of funds. If we all missed it, what's the standard?
Right.
You have to show an aberration, a breach of a duty there, and that's going to be difficult, but we'll see what the facts bear.
Well, you've never backed out of a tough fight in your life. Rick Stone, good to see you, my friend. Thanks for coming in. Appreciate it. Some of the